My name is David Majanja, Judge and Commissioner.
Thank you, Judge.
Yes, thank you very much, Honorable Commissioners, for that introduction. We will straight away go to the interview. Mr. Muteti, we will be asking you a few questions. We have read your CV and the other documents. Just start by confirming your county.
Yes, thank you, my lady, Honorable Chief Justice. As you've stated, my name is Alexander Muteti. I come from Makueni County, that's where I reside, having moved to Makueni way back in 2007, originally born.
Ethnicity?
I'm Kamba by tribe.
Thank you very much. The next set of questions will be asked by Justice Ishari.
Thank you, Honorable Chief Justice. Mr. Muteti, looking at your CV and your letter of application, there is no doubt that you've had a very illustrious career in the public service as a public prosecutor.
Thank you, my lady.
I think it now spans a period of over 23 years.
23 years, precisely, my lady.
Why do you want to become a judge?
Thank you. Good question, my lady. Honorable CJ and Commissioners, I having served for 23 years as a public prosecutor, I think I have come to a realization that I have done more than enough in that area, in the sense that in terms of jurisprudential development around the area of criminal law, I think I've proven myself in that area. I have also been able to participate in quite a number of activities in promotion of the prosecution service, and I consider this as an opportunity for myself to render service to the Kenyan people in yet a different capacity, but relevant to my training and experience.
Just listening to that very brief introductory, don't you think that the office of the DPP will be greatly disadvantaged if you were to leave them?
Well, my lady, I do not think so, for quite a number of reasons. Number one, in that office, we have a structure that in it, at the senior level, currently I am at the rank of a Senior Assistant Director of Public Prosecutions. We are more than 35 in that rank. And others have been recruited recently, I think an additional 5, bringing it to about 40 Senior Assistant Directors. Above me, there are 2 Deputy Directors who are still in service, so that looking at the institution and the fact that I have also been doing serious mentorship of my colleagues, that if fortunate enough to be taken in as a judge, I'll leave behind, I have absolutely no doubt that they will still be able to discharge their mandate.
All right. Again, listening to what you've told us, it is so clear that your specialty has been in the area of criminal prosecution. And when you become a judge, there is a possibility that you could even be attached to the commercial division, for instance. How would that be now, given the fact that your life, yes, nearly all your public life, you've been a public prosecutor dealing with criminal matters?
Thank you, my lady. Let me correct one thing. When I joined as a prosecutor, largely, I was posted first station to Meru Station, where at the time, when I was in the office of the Attorney General as a State Counsel too, we were handling both criminal and civil matters. Later, of course, after the office of the DPP was delinked from the Attorney General, I moved on to prosecutions, but within prosecutions, I currently head the Judicial Review and Constitutional Petitions Division, which I have done for the last 6 years now, so that I have a good grounding on matters judicial review and constitutional litigation, besides what I have been doing in criminal law practice.
Fair enough. And finally, from myself, you do indicate in your letter of application that you possess personal attributes for this position of judgeship. What are these personal attributes that you think you possess that are ideal or make you the ideal candidate for the position of a judge?
Thank you, my lady. First, I would say as a person, I am a very good listener. That helps me when making decisions about anything, that I take the advantage of listening to everyone that comes before me before I make a decision on whatever issue that I'm looking at. Secondly, as a public officer, over the last 23 years, I have learned on the job certain things that public officers must never do. Number one, on issues of integrity, I have no doubt I am a person of integrity. Reason being, if you're a public official, you are unlikely to survive that long if you are not a man of integrity. Why do I say so? You'll be required to do things both in private and in public that persons who lack integrity would not escape public notice.
Thank you. That's all from me.
Thank you, my lady.
All right, just a few questions.
Yes,
Now, I'll not test your legal mind. I have no doubt you have a very good legal mind.
Thank you,
I want us to discuss a different issue.
Yes.
Now, the administration of justice ecosystem.
Yes.
What do you think is the biggest challenge, or at least if not one, at least two challenges that you think are facing the institutions, the governance issue institutions that relate to the administration of justice?
Thank you, Commissioner. First, I would identify the question of stakeholder collaboration and cooperation. For a very long time, public institutions in this country involved in the in the justice system have been operating on what I would call a silo mentality approach to issues. So that when the judiciary is under-resourced, it is not the business of the Attorney General to speak about it, or it is not even the business of the DPP to speak about it. We must, as a country, agree for us to be able to deliver to the people of Kenya. We must change our approach to some of these things. Secondly, the resourcing of our institutions that are charged with the administration of justice. Take a population of 50 million Kenyans, and the statute as it stands today contemplates a situation where you have 200 judges in the High Court, for example. Given full and optimal capacity, you will have to match those numbers with 50 million, and given the case rate that we have in this country and the litigious nature of Kenyans since the promulgation of Constitution 2010, you still realize we are far from it. And the public needs to be served more expeditiously, efficiently, but we cannot do so without resourcing the institutions so that they increase the human capital as well as institutional infrastructure.
I want us to address the fear of the public.
Yes.
When they look at the governance institutions,
Yes.
the commissions, the judiciary, the ODPP, all those institutions. What do you consider to be the biggest fear today that the public has, or the perception they have vis-a-vis the institutions that I've made reference to?
Well, I would say this, out there, the public that we are serving seems to have a very low confidence level in terms of our ability to deliver on our mandate. But I would not blame it on anything other than the lack of information on their part. Reason, having practiced law in these courts, I have seen judges, and His Lordship Judge Ibrahim, before whom I appeared for the longest in Mombasa, a judge sitting in court from 9 to 5, and you expect them to deliver judgment in time, handling not less than 10, 15 to 20 matters. That is impossible. So that the public also needs to be sensitized and informed. And I like some of the things that I've come across when looking at the vision of the Chief Justice on how we need to approach justice, that we need to sensitize the public and make them aware what are the challenges, what are the opportunities that lie within the justice sector that we can leverage on. Yes.
But if you know, and I'll not take too much time.
Yes.
Now, what is it that you think then that needs to be done, and what did you do as a judge to increase the confidence level? Because we would be lying to ourselves to say that the confidence levels are not dipping generally when it comes to institutions that are meant to ensure the administration of justice is one that people have confidence in, unless, of course, we want to, we are not living in this country.
Thank you, Commissioner. Given an opportunity to serve as a judge in the station that I would find myself in, I would do two things. Number one, utilize the CUC that exists in the court stations to come to some consensus with all the stakeholders what needs to be done to do this job differently. What is it that is the challenge that we have to contend with in terms of progressing our matters? Why is it that cases take so long? By doing so, from the CUC, you would be able to tell, for example, is there a need for us to change the way we do cases? Are we going to adopt virtual court hearings? Are we going to move away from oral testimony to hearing of cases by way of affidavits, so that we are able to approach this matter in a holistic way and at the end of the day win the confidence of the people? There is yet another window. I have noted of late the judiciary has gone out, something that never used to be to happen before. The judiciary was known to be an institution that everybody dreaded, but at least now there is interaction, public interaction, so that the stakeholder needs to know what they expect from court, what is expected of them, and why certain things take so long to happen. Thank you.
Now, my final question,
Yes, Commissioner.
and this is not to you specifically, but I'm now referring to the role of prosecution vis-a-vis the constitutional rights that Kenyans were granted under the Bill of Rights. Now, there has been, a lot of complaints generally, and I'm sure you've seen that, as people engage in a discourse regarding where members of public who are just exercising their rights to demonstrate, then, their rights are abused by the police. And when they appear before court, again, the prosecution is the first one to insist on very stringent bail terms, or even refusal of, bail or bond, when they are simply exercising their rights. And sometimes you find that very poor people, the prosecution is insisting on very stiff, bail terms. I would want an answer, your view regarding that. Because, see, I would want to believe that one is first a lawyer before they even say that they are acting for the state. That's one.
Yes.
Then secondly, again, it has been in public domain, and again, I want to caution that this has nothing to do with you as an individual.
Yes.
I know you to be an excellent officer, where you find that cases that are almost being concluded, corruption cases, where substantial evidence has been submitted, then again, the prosecution or the ODPP is coming to apply for withdrawal of those cases, leading to suspicion by the members of the public that the ODPP has been captured and is now geared towards, not supporting the war on corruption. Now, and there has been, again, in public domain, there has been altercation or exchange between the courts and the ODPP regarding the issue, and also even AACC. Now, to come to the question, what do you think that portends for confidence levels in respect to the issue that I've just read about administration of justice? That is one. And for you as a judge, what do you think is the role of the judiciary in ensuring that at the end of the day, that the public can look at whatever is being done within that ecosystem and they can have confidence that there will be justice, whether for the victim or for the public or for the accused? It really doesn't matter in terms of confidence.
Thank you, Commissioner. Let me begin with the issue of bail that is being granted, or terms that we ask for in matters of persons arrested during riots or public demonstrations. And I would say this, for purposes of information, Commissioner, I had the privilege to argue the first bail application after Constitution 2010 before Honorable Justice Ibrahim, the case of Mugunya, Danson Mugunya. And in that decision, there is a checklist that the judge has ably laid out in that decision that one needs to look at. So that for me as a prosecutor, and even as a judge, if I were to be one, I would be able to find able guidance within the precedents that exist in this country on the issue of bail. It matters not what a public prosecutor will tell the court, as long as the law says you can give bail, then nothing stops the court from doing so. And no one should begrudge a court for simply giving bail, which in any event is a constitutional right. And what I would say is this: courts should stamp their authority. When we make applications, we are not a special litigant. We are a litigant like any other, only that then we come under the color of public interest at times. And then you weigh what are the consequences of some of the actions that these people are involved in. What are the reasons that you lay out? And most importantly, in the applications for bail, there is a requirement that you file affidavits. What are the reasons that these prosecutors are presenting before these courts? So that, for me, I would say it is up to the judge or magistrate before whom we appear to dictate the terms, because that is what the law requires of them, and nobody should take offense of that. Now, the right to picket under the Constitution is a guarantee, and that we cannot take away from the people. So that if they engage in demonstrations and they are arrested for any infractions that they may find themselves involved in, then there is every reason, of course, for them to be charged, because, again, a demonstration or participation in picketing does not mean an open check to commit all manner of offenses. We have had instances where people are attacked by persons purporting to be on some of these demonstrations. Then I turn to the question of withdrawals at advanced stages. There is a myth, let me call it so, that has gained some kind of public acceptance, that the DPP is withdrawing matters left, right, center. That I would wish to bank by saying this. If you read section 87A of the CPC, for instance, a withdrawal can occur at any time, even before judgment. That statute is dry in the sense that it doesn't tell you what are the reasons that the DPP must give before such a withdrawal happens. Therefore, then it takes you to the question, when an application is made for withdrawal of a matter, the most important and critical thing that Article 157 requires of the prosecutor to give are reasons. Are these reasons that are being advanced reasonable enough for a court to reach a decision to allow or to disallow a withdrawal? Why do I say so? The constitutional architecture creating the office of the DPP allows him to withdraw matters, and there are very many reasons that can lead to a withdrawal, and I will list just a few if you allow me. Number one, you get a very good case to court, witnesses are compromised. That does not happen when you are in the know. Witnesses are threatened at times. That does not happen within your knowledge. But when you call them to come and give evidence, witnesses start giving you excuses, left, right, and center. Oh, I cannot be released from my place of work. Oh, I have a sick child, and all that. You get to a point, some will tell you expressly, and these are matters that you cannot, of course, come to court and start saying everybody has run away from my case. If you have no evidence to offer, you will say I have no evidence to offer. But there are certain things that always will inform a decision to withdraw a matter. People may think it is abuse of power, but then what is the function of the court in terms of supervisory jurisdiction to supervise the DPP? When you have good reasons to challenge that decision, nothing stops anybody from applying to the High Court under judicial review. You can seek whatever order you want, mandamus to compel the DPP to prosecute. If you are successful, that happens. There is also the option of private prosecution. If one believes DPP is withdrawing a matter simply to assist a particular accused person, then there is that option of private prosecution. But I can tell you, for the few that I have personally presented applications to withdraw, we have had valid reasons to make such applications. Reason You have a matter, you have reached at witness number 22, and the rest of the witnesses are reluctant. What do you do? And you have not proved anything. You look at the file, there is good evidence, but nobody is telling you why these witnesses are not even ready to come and give evidence. Those are realities we have to confront.
Just taking it further from that question about public confidence
Yes, my lady.
in the judiciary, I just want you to tell us why although the independence of the judiciary is underpinned in the Constitution, we still